Well, good afternoon to everybody. It's Wednesday, October 23rd, 2013. I'd like to welcome everybody to the Land Surveyors Board meeting. It's now approximately 1:05, and we'll get started. Basically, we have a short agenda for this afternoon. We'll try to work our way through it, and tomorrow we'll have rulemaking hearings, and Friday we'll have some other business to conclude. So have a 3-day meeting this time, and look forward to a very positive meeting. The first thing we need, first order of business, is we need to adopt the agenda. And I'd like to ask if there's any additions or corrections to the agenda by anyone. We have some topics that have been bounced back and forth between Rob and I, in particular, that I hope that we'll be able to discuss through the course of the agenda. If we need to add them, we will. I think that it would be appropriate if we did. One item is a clarification of, and I think I forwarded it to everybody, but I think I'd like Rob to speak about it. Clarification of the Tennessee Condominium Act of 2008. I'd like to add that to our agenda. It'll be presented by Rob. Also, I think we need to continue, and I don't see a place for it, but I think we need to continue our discussion on our out-of-state applicants, time-related on licensure, and I think that I would ask Ms. Nicole to address the meeting that was held with the assistant director of the department relative to the 10-year rule.
We're not supposed to.
Well, let me just ask a question, and I'm going to stop in this process to ask a question. Each year, annually, this board votes to function under Robert's Rules of Order with no specific criteria of deferring from those rules of order. And under Robert's Rules of Order, it allows for the agenda to be amended. Now, we've had this discussion before that stipulates that the board is not to have items on the agenda that are new, to be newly placed, that would require any action of voting by the board, because it may not be in the interest of the public, and the public needs to be properly notified, and that's why the agenda is posted on the website. As chairman, I understand that. But as chair, I have a great difficulty understanding how we're empowered and directed to operate under a set of rules and guidelines for our meetings, and then we're told that we can't go by those rules and guidelines.
Part of the meeting, but I believe Donna brought the copies of the open meetings requirements and the sunshine rules.
I didn't know we were going to do it until my.
Bring the packets, though?
I didn't bring them. I printed them. They're upstairs.
Okay. We'll make on the next break.
Although if that's an item that we need to discuss, that should be added to the agenda.
But anything that would affect the licensees or the public may have an interest in, any topic that could be posted on the agenda, of interest to outside or affect outside parties, even potentially on future action, published so that interested parties can attend.
Well, I don't mean to be disrespectful, Ms. Nicole, whatsoever, but we have attempted to have agenda items before placed on the agenda for discussion, and they have been removed. So I don't know how we are supposed to discuss certain things when, if they're attempted to be put on the agenda, they can't be put on the agenda, and then when we come to the meeting and we ask to amend the agenda, we can't amend the agenda. So I'm really struggling with how we're supposed to function when we have matters that may be very important to any member here. not just the chair, any member that's sitting before you.
Anything that could affect the licensees has to be on the agenda. If there's something specific, it should have been on in advance of the meeting, along with any documentation associated with that, so that it could be.
Well, I would respectfully request that if there's someone in the department that manages the topic that you're referring to that could come and address that and allow us to ask them questions, that I think that would be a marvelous way of clarity for this particular issue, so that the chair and this board will be able to function in the manner that the department and the legislature is requesting us to function under.
Tim, would it be possible, since we will be convening on Friday, to possibly get some kind of resolution or answer to these questions before Friday, such that if it does cleared up and we are able to amend the agenda, that we can handle that on Friday? Would that be possible? That way we
That'd
don't.
be great. Yeah, that'd be great. Yes, sir.
Would that be adequate time?
The Open Meetings Act requires. Do you have that information?
I just feel like it's pertinent and prudent that if the open meeting rules are different than Robert's Rules of Order, or they are an amendment thereof or whatever, then I think that's the rules that we should approve and should also be familiar with, so that we function in that manner. That's the only thing. That's the only point that I'm trying to address.
The open meetings rule or law says that you can't deliberate unless it's in an open environment and notice is given to the public. It doesn't really dictate how meetings are conducted. It just means that you can't take action. For instance, you can't make decisions that would affect the licensee or any other regulatory policy the board regulates without it being in an open meeting and agended and announced.
And I think we all understand that. I think we understand.
It means you can't just call each other and decide what you're going to do about a licensee, or the board's going to take this position at the next meeting.
I understand.
You can't do that.
Right.
That's what it's transparent government. You can't make policy decisions which just affect you, or decisions that affect licensees.
I think any of us have a problem with that at all. It's just the fact that there are things that we need to discuss, and we feel like that we need to discuss that we're not being able to because they've taken from the agenda, and I think, and those things would affect some of the licensees and that kind of thing. I think something that was said that was required legislative action was one reason, and one item that comes to mind was this thing of compensation for our review
Advisory board.
Our advisory board, concerning continuing education courses that come in, and we had talked briefly about that, but they said, well, that's going to take legislative action. So, and from what the last I heard, that item had been pulled from the agenda because I thought, well, we want to get a chance to talk about it, and so it was pulled from the agenda. I said, well, why? And they said, well, it takes legislative action, and you can't talk about that. I thought, oh.
Not under your legislative authority currently to charge fees for education review. That we couldn't find it anywhere. We looked.
We understand that, but
so you would need to propose legislation either through your professional organization or directly as individual members of the licensees. But it's not currently under the board's purview to do that. Something that's outside the authority of the board, you don't really have authority outside that legislative body. So anything that's in the laws currently you have authority over, but short of proposing new legislation, there's that you add fees or do any of that because you don't have authority to add fees for.
Understand what you're saying, and we understand that, but we wanted to discuss that very thing as to how what vehicle, how do we go about doing what we need to do? And I don't need to get into that right now because we're not ready to get into it. But anyhow, that's the type thing. And if we can't discuss things that would affect, parts of our survey cadre that we have here in the state, then I'm not sure what maybe we're sitting here all the time for, because there's a lot of things we need to do for us that taking care of standards of practice and discipline and that kind of thing. But when it comes to something else, and these things affect us as far as each individual surveyor, that we have to take continuing education, and we have an advisory board that reviews these things, and we wanted to see that, like our expert witness program, the advisory board ought to be compensated for what they're doing, because heaven forbid that they review more than 200 or 300 courses that come before them every year, and maybe even more than that, and screen out the garbage so that we get quality type courses that are offered to us for continuing ed. And so that's the type thing, that's what we wanted to talk about. And whether, if we're not allowed to talk about that, then, that kind of
I'll let Robert answer questions on how to propose legislation.
Well, let me interfere just a moment, if I may. I would again respectfully request, based on the comments by Mr. Kaufman, that if there is documentation that tells us how public meeting or our meeting is to be conducted and that type of thing, I would respectfully request that we be provided with that documentation and it be explained to us by someone that is thoroughly familiar with that documentation. And I don't feel like that is out of line.
I don't think that's out of line. In fact, it is the plan, according to one of our legal counsels. For every board and commission under commerce and insurance. So
Real quick, is that, if I understood Nicole, the information is collated and it's available? It's just upstairs?
I've got it upstairs
okay.
in my
Do
office.
you think we could get that by the end of the day?
Sure.
Great. That'd be good.
Okay, let's move forward. We need a motion to adopt the agenda as written.
So moved.
And we have a second.
Second.
All those in favor?
Aye.
Opposed? Okay. Okay. This regularly scheduled board meeting is taking place in Conference Room 1B of the Davy Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee, and notice of this board meeting was posted on the Land Surveyors Board website, I won't read out the website, on September the 6th of 2013. Okay. Now, I think we're official. First item is to review and approve the minutes from our August meeting. I hope the members received their copy. And if you have received your copy, are there any additions, corrections, deletions that need to be made to those minutes?
There's no changes or amendments. I move we approve the minutes.
Okay, we have a motion to approve the minutes as written. Do we have a second?
Second.
Okay, we now have a second. If there's no further discussion, all those in favor say aye. Aye. Opposed likewise? Okay, the minutes carry. Okay. Next item, Mr. Herndon, that would be you.
Again, I'd like to congratulate our whole profession, because there are just not many complaints, and there haven't been for a while. We've only got 2 this time. That means everybody's being good, I guess. So this is a brief one.
Will we be receiving a copy of that?
It's on the iPad.
We do not get it in paper?
One hard copy.
Okay. May I have it in paper, please? Thank you.
Number one is a revisited case. Case number 2013-016431. This matter you got to see in February, and in italics it has on here how that was presented exactly. This has been a while. February 2nd of last year. This case was referred to Mr. Cagle actually to look at the materials and see if there was any indication that this particular respondent had deviated from our standards of practice. Mr. Cagle looked at it and brought it back to us and explained to the board at that time that he didn't see any indication that there was any deviation and that we should close the case. And the board accepted that one. Well, in the interim, it's come back to us. I reviewed the materials again that were sent in under color of being new, but they need to be not just new but relevant. So I compared the old materials to the new materials, and there's nothing that would have changed your mind at all from this new material. So the recommendation is dismiss this case with prejudice for lack of disciplinary grounds. And I think the chairman could probably explain to the newer members that sometimes we have to do this because they just keep coming back. If you do dismiss this, I will write a special letter to the complainant explaining why, and that you probably need to find another venue to find the satisfaction you're looking for. But
I think what Rob's saying, Jay, for your benefit, is sometimes we get claimants that are infatuated with their claim. That, in other words, it's such in their mind that they just know that it's wrong and that this board needs to do something in their behalf. And when the board reviews the complaint, we find, thank you, sir. We find that there's no merit for the complaint against the respondent, and we act appropriately. But then what happens to us is it kind of keeps coming back. It's kind of like the bad penny. It just keeps turning up. So in order to quiet it, basically that's why we dismiss with prejudice. So we basically quiet the case, and what it really does is then it forces the complainant to really find something new, something different, you know. In other words, if he said it was blue all along, somehow or another he needs to figure out that it's now red, and then maybe the legal department can look at it if it is that different. So that's kind of where we're at on this.
Usually they find an old deed, or they don't find anything. They're just convinced that this guy didn't go by my deed, or he didn't look at the deed, or he did it backwards. And even if he did, it doesn't necessarily deviate from the standards of practice that we're concerned with. Even if it's sloppy and it's still within what we would consider a good job, then and that's why it's dismissed with prejudice, because it's sort of against public policy for us to hear the same thing over and over and over again. We need to dispose of matters when they come up. So that's the reason for this. And I didn't put it in the recommendation, but I'll make sure that the letter that goes out explains why you decide this, if you do decide it. That's my recommendation.
Thank you, sir. Are there any other discussion about the matter?
No.
Have a motion. Do we have a second?
Second.
Okay, we have a motion and a second. Any further discussion? If not, I'll call for the question. All those in favor say aye.
Aye.
Opposed? Okay, motion carries.
All right, our one and only new case. This is case 2013-015781. The complainant alleges the respondent, a licensed surveyor, committed misconduct in professional practice by getting involved in a conflict of interest. It's kind of interesting. Specifically, the complaint alleges the respondent improperly purchased land owned jointly by the complainant and a complainant's sibling without informing the estate attorney. The respondent was hired by the estate attorney to survey property owned by the deceased. The property then passed to the siblings, one of which is the complainant, and to serve as a special commissioner to suggest a partition of the parcel. And along with the respondent, there was a real estate appraiser who is familiar with the property, and a former circuit court clerk who ended up being the third commissioner. The partition was signed by the court on April 29th of this year, reflecting its decision on April 10th. On April 18th, the complainant asked the respondent to mark the partition, which he did for a fee. After other attempts by the complainant's sibling to sell his part of the property, the respondent, along with some investors, purchased it. The respondent has not provided any further professional surveying services since these events. So, I recommend close the case for lack of disciplinary grounds. And I don't know if you understood exactly what happened, but I'll answer any questions. I don't know if you're familiar with stuff like this. You may be.
It's not uncommon in East Tennessee for an officer of the court to contact my office and ask that if I would be involved in the division of property as a commissioner, and usually what they do is they'll select a surveyor, a real estate agent, an appraiser, and maybe a couple local farmers or whoever. And that makes the commissioners people that are familiar with it and so forth. And then generally those are the same people that actually do the work. So I don't know if it works that way with you guys too, but it works that way at home.
Yeah.
So I don't see anything. The fact that he ended up purchasing the property, that's kind of up to him, I guess.
Yep, that's what I thought. And there's
Got the bucks in the account and he wants to buy it. And if the folks that sold it to him, if the other folks that didn't like it, and I'm sorry, I don't see anything there that.
part of what I took away from it. That and the fact there's no complaint history for this particular person. So he doesn't make a habit out of getting in trouble or doing something he shouldn't do. So closure.
Any further questions or discussion?
I make a motion that we close it with.
Second?
And we have a second. Okay, we have a motion and a second. All those in favor? Opposed? Okay.
But because it's the legal report, I like to consider that it's not just complaints, but it's also a time to offer advice to the board. And since that's what I'm supposed to do, I got a communication about the condo law from the chairman, and this is my advice to the board based on that. There's a passage that passed in that law that says, well, it's 40 pages, but the salient part says, any certification of a plat or plan required by this section must be made and signed in original by an independent registered surveyor, architect, or engineer, or combination thereof. And I suppose that there was some concern in the wide world that this would allow an engineer to stamp a plat, but that's not what that says. As a matter of fact, the passage goes out of its way to say plat or plan, which distinguishes what a plat is in design documents. So the law is, as it always has been, only a surveyor can survey and only an engineer can engineer, and that's what this says. I think I've stated that correctly. So if people have been asking, or if an engineer attempts to stamp a plat and we get a hold of it, then that's unlicensed practice, just like it always has been, whether or not they're designing condos. Now, there's been some questions about the 10-year thing, and we had a discussion about that within the department.
Rob, before we leave this
Okay.
this condo thing, the reason it came up, the Davidson County's mapping facility right across the aisle from the Planning Commission, came to me while I was in there to pick up some information, and he handed me this plat. And it had an engineer stamp on it, but they had filed that thing to be recorded as a plat of a condominium or what have you, with the meets and bounds on it and everything, but no surveyor stamp on it, just the engineer. He said, I didn't think that engineers could do this. And I said, well, I know that this horizontal property regime thing and a condo, I said, there are some things you're going to have to read closely, but I said, if it walks like a duck and quacks like a duck, it's got feathers like a duck, it's a duck. And I said, if they did a survey, it's a survey. And so as I look at that, and I saw the document, I said, why don't you file a complaint? Because if you don't know how to handle these things, and David Klein in the mapping department down there said, well, what should we do? He says, these things come in here, and said, we're going to have to do something with a document so that the property assessor can assess taxes and do this kind of thing, what have you. And I said, okay. I said, I still think you need to file a complaint, because I said, this document has apparently been filed for recording without a surveyor stamp on it, but an engineer stamp on it. And I said, maybe the engineer is saying, hey, this is just a plan rather than a plat.
I've seen this, actually, the reciprocal of this in
Yeah.
the fire marshal's office, where the design package will come in with a plat in it, stamped by a surveyor, and the plans guys will call it, hey, this surveyor's stamping a site plan. It's not a site plan, it's a plat. And some people can't tell the difference, I guess. If it has design elements on it, it sort of becomes a site plan, and an engineer can seal it if they're changing something. If it's a measurement plat, then it's a survey. But there are some people that have trouble telling the difference if they don't know what they're looking at.
In this particular case, the assistant in the office over there is a surveyor. And so he knew what he was looking at. And so he asked me, and I said, well, the thing for you to do then, I said, file a complaint. I said, because we can't act on anything unless a complaint is filed about the thing.
Can't control who files things, and if
Yeah.
whoever accepts the filing, we can't control it, but who stamps it, we do have jurisdiction over.
What's written here is fine. I don't have a problem with that. And
It's pretty plain.
I'll tell you, I'll take a copy of that back to mapping over there, and I'll let them have it. And I said, then you decide. I said, if you get a plat that comes in here, and it's a plat, and it has no surveyor's stamp on it or signature, I said, then the first thing you need to do is file a complaint. It has somebody else's signature and
I wonder
stamp
if
on
the
it.
engineer stamped it thinking that it was just part of their
Well,
package.
I thought first that maybe you should go and call the
Yeah.
engineer and say, is this just a plan, a site plan that you have done, or was this done for recording purposes?
Yeah.
'Cause I don't want to get the engineer in any kind of hot water because he thought he has designed a building and what have you, and even though he put the surveying elements on there, and it may have been done by the surveyor, I'd rather the engineer have an opportunity to say, oh, excuse me, I shouldn't have done that, or whatever it may be.
Yeah, that's what I like to give
But-
them the opportunity to
yeah.
correct it.
But I'm not on a witch hunt, but I'm just saying that this horizontal property regime, I know that the folks over at mapping here in Davidson County, they don't know how to handle some of these things sometimes. And they were just looking for some guidance. And I said, well, the best thing for you to do, file a complaint. So,
That's my opinion about it. I think that this doesn't change anything. I think it's what it always has been. And surveys are surveys, and civil site plans are civil site plans. And never the twain shall meet. But I think, I guess that'll do for my legal report for now. Do we have a guest here?
You can do
I'm going to give
That
the director.
concludes your legal report, Rob?
Yeah, just there were complaints. I wanted to clear up that one legal issue that was asked to me. So
Thank you.
we're
Go ahead. No, go
He
ahead.
started into the 10-year rule. Was
Oh,
that-
that's right. That is correct. You did start that.
We can handle that when we get closer to applications, but the discussion within the department was, after looking at our policy that we worked so hard on, is that there's some people that are continuing to be approved for the exam that were approved for it before y'all were here. But they don't qualify to take the exam, so we're going to have to cease that practice. If they're not qualified to take the exam under any circumstance, then they can't be approved. And it's sort of just as simple as that. Just adhering to our policy, and I'll put something in writing and distribute it to the board members that sort of memorializes that, but I just thought before we get to Friday or tomorrow afternoon or whenever you start, because they're probably not going to like it, but that's just the way it is. And
Okay, well, thank you, Rob. Next on the agenda is the director's report, Ms. Donna.
Okay. Our Assistant Commissioner Bill Giannini and Kimberly Whaley are here to to meet with the board to discuss the budget.
Good afternoon.
Good afternoon.
How
Thank
are
you.
you?
Thank you very kindly to come to speak to us.
Glad to. Need to get us here from my right arm though. How are y'all?
Hey, how you doing?
I'm good. I'm good. I'm glad you all made it to Nashville safely. Good to see you.
Long trip for me.
Where did you come from?
L.A., Lower Antioch.
Lower Antioch. Oh, man. You did have a drive. Well, we're not going to take up too much of your time. Wanted to, for those of you that don't know, this is Kimberly Whaley. We don't have enough time for me to explain everything she does for the Division of Regulatory Boards. But one of the most critical things that she does is she manages the accounting functions for us and makes sure that we're not spending more than we're taking in. And so one of the reasons something that we wanted to do is and we're going to start doing this annually after budget close, is coming before you all and presenting your close numbers, let you see where you're at, and then talk about anything you want to talk about. We'll talk about some non-budget related things that we're doing, but the primary goal here is to make sure that you guys are kept in the loop with about your administrative operation. So, and I think you all have a copy of the close there. Yeah. All right. I'm just going to kind of run through it. At any point, if you want to ask questions, feel free to. You can stop me at any point. This is fiscal year 12 and 13 is known in regulatory boards as your down year. You have an up year and a down year, as you know, and this was your down year. You can see at the first line is your regular salaries and wages was 37,188, which is lower than it had been the previous 2 years, and just barely over what it was in 9 and 10. And then if you look down at your employee benefits, those again were lower than the previous year. And then with all total payroll expenditures was 55,448, and was again only second to year 9 and 10. Travel was up a little bit. We didn't feel like that it was enough to worry over. If it was substantially higher than it had been in previous years, we would have probably investigated it, but we think that that's fairly consistent with additional costs of things as we know they are these days. Then you can drop down into your expenses, excuse me, and you can see at the bottom, again, they've held very consistent. Your total expenses 120,453. The previous year was 123,602. Both of those years are lower than year 10 and 11, and again closer to year 9 and 10. So from an administrative standpoint, your staff is doing a great job. They're managing the money. They're staying very consistent, and hats off to them for doing that. Then if you drop down and look at your revenues, you can see that you had, again, this is your down year. You had $30,190 in licensing revenue last year, $373,073. Another thing that we're doing, we're adding to these reports now, is separating out your complaint revenue money. So money that you all receive from consent orders and disciplinary actions, we're pulling that out so you can see that. We just feel like it's helpful. This past year was $8,779. And if you drop down to for the fiscal year balance, you guys were negative 139,784, which is not unexpected, at all. It's very consistent. If you look back at year 10 and 11, which was the last comparable year, you're right in line with that. And then your fiscal reserve balance is 141,137, which is the very last number that you see. Good. You have, I want to talk a little bit, you had a total of 1,171 licenses, 14 complaints. You guys are 0.5043% of the total licenses and reg boards, and you're 0.5773% of the complaints. So you're right there in line. You're not your guys are not big troublemakers. So, sir?
This has been a concern.
I think, again, before I go and talk about some of the initiatives that we've had going on, I want to, and I'm probably preaching to the choir, but you all have a great staff in land surveyors with Ms. Mulder and Ms. Avers. They do a great job. They keep their people doing what they're supposed to be doing. And if all of my programs ran as smoothly as the programs that they manage, I could come in late and leave early every day. So they do a great job, and I think it's evidence here in these numbers that they're taking care of your money wisely. As you all know, we have to keep you in the black. We're statutorily required to do that, and they help us accomplish that mission every day. We have a couple of initiatives, I think, that are exciting. We are buying a new licensing system. You may or may not be familiar with the RBS system, which is the system that we have had here since Ned McWhirter was governor. His administration actually bought that system, I think, in 1993. So it's 20 years old, and in computer age, that is and prehistoric, not only antique, but prehistoric. And it is a very old system. It has served us well, but we are getting a new system, and we're investing a substantial amount of money in that. And the department has been conducting training and areas of expertise. We're including every program is involved in the construction of the new program, and so that's an exciting thing for those of us. We think that's going to kind of take us into the next stage of technology, kind of where the public expects us to be, but we're not quite there yet. So we are working forward to implement that. We've implemented the e-Notify, which is electronic notification of board information, legislation, anything pertaining to your program. You can now be notified by email. Have you all signed up for that? Good. Everybody signed up? That's great. That's good. This is only the second one we've done of these presentations, but the first board that we talked to had, I think, only 2 of the members had signed up. So you guys are the leaders at this point. I'm glad to see that you're doing that. And as we move on, we're moving more to paperless on anything that we can. We have moved locations, as you all also know. That translated into a $600 a month savings for your program. We've got newer, nicer space. It's a little bit smaller, but it is, again, that's saving money for your licensees at the end of the day. That's about it, I think. Customer-focused government. We're doing one of the governor's big initiatives is to improve the customer service experience for anybody that does business with the state of Tennessee. You all, our customers, is just as much as a licensee. And he's in that respect, he has implemented a program called Customer Focused Government, and every single state employee has to participate in that training. We have just, I think this morning we finished our 7th training. They're classes of between 25 and 30 people, and they've been received very warmly by the staff. I think they're having a good time, and I think that you're going to really see an improvement in the responsiveness, not in Department of Commerce and Insurance so much, because we were already awesome, and we kind of know that, but other departments in the state are really going to benefit from it. So it's really an exciting thing. And we're making investments into the technology. We are spending the money to give the people the tools to do the job that they need to do as efficiently and as effectively as we can. And with these programs, your program especially, Director Avers' programs, we get a lot of compliments about the responsiveness of the staff, and they're kind of the leader in that for our division. And we're just grateful to have them, and I'd now like to ask you to ask me anything you want.
I've got 4 questions.
4?
Out of all of that. How about that? That was pretty good, I thought.
That is pretty good.
Well, none would have been better, I'm sure.
Well, let me hear them first.
Okay. First question I have is about the new computer system that you're speaking to.
Yes, sir.
Currently the system, and this is more of a curiosity as much as anything, currently the system that we have is if an individual makes an application to take an examination that would subsequently lead them to licensure, they are given a number in the system. And that number basically stays with them from the time that they come into the system until they become licensed. For example, let's just use the number 3,000 just to pick a number out, okay? If you applied to take an examination as a surveyor, you would be given the number 3,000. And as long as you continue that process, when you actually pass the final examination and the final criteria, and you became a licensed land surveyor, your number would be license number 3,000. But what we see is we have all varying situations that go on. We have an individual that, one, does not carry through with that, starts and stops. We have an individual that may not qualify after they've gotten the number. We have an individual that maybe even might have become deceased in between that time. So what we end up with is a large group of numbers that potentially a fair portion of them are never used. In the old days, I'm a dinosaur, so in the old days, when you got your license, you got the next number. And that's just something that I wanted to kind of point out, because you can go on our website and you have all those numbers up there, and it has a status about it of whatever your status may be, but that person may never get the license. For example, going back to the deceased individual, if that person applied, maybe took the first exam, and then became deceased, well, that number's dead forever, if that makes any sense. So I'm kind of that way about liking things in an orderly fashion, and having gaps in my mind for somewhat no reason doesn't make a lot of sense to me, even though I understand how the system works, that you got to assign a number somehow and track it somehow, and that's in the tracking part of it.
I guess I'm getting an education here on that, because is that so if I went into RBS and did a search, someone like the example he gave would be someone who's passed away and never went through would still show up in the system as what?
Never were approved, it would stay. There's a file number and there's a license number, and many times those numbers are the same. But when a person applies, they're given a file number, which is issued sequentially. If they never succeed in becoming licensed, that number never becomes a license number. It's never communicated to them. There's no card printed.
Right, it leaves a
none
gap.
of that. Yes. There would be, and there would continue to be. So if your license numbers will carry forward into the next licensing data. So it'll tie to other professions now in the new system, where if you hold multiple, there is a file number associated with each of multiple license numbers, and they'll tie to each other. So that is part of core.
Right, but there's currently the licensing scheme is, as you said, the person is issued a number. That number will stay with them. We will not be reusing or giving that number to someone else. We maintain the history. That allows us, if someone were to, say, come in as a student, take the application, and then suddenly move to another state, and at some point later come back, we will already have their information. So we wouldn't be deleting any history.
Like I say, that's more of a question of curiosity. The other three questions have some more meat and potatoes to them.
But that would be available externally?
There's some discussion.
access?
You're referring to license search. If you go out and do a license search,
I'm just talking about the void in the numbers is basically what my concern was. In other words, let's go back to the example I used with the gentleman. If his was license number 3000 and the next 25 people were people of issue that never got to licensure, well, the next licensee would be 3026.
yes, that I'm not aware of the licensing, the numbering scheme changing with this system.
Okay.
Make inquiry
Just a question.
of our ISC.
It does, that number does show up on the website too, if somebody goes in and looks at it,
You're referring to verify,
right? Whether they're licensed or not.
if they're an applicant.
Right.
There's a file number associated with it. Expired, in process, active, denied, revoked. It'll say which status.
The fact that we keep the license number and file number the same, basically, for ease of use, prevents going from license number of 3000 and then issuing, having several applicants and then issuing the next number. Our licensing number and our file number would be different.
Okay, well,
Our
the system back in dinosaur days when I got licensed was when the applicants actually passed the state-specific examination and the licenses were given out, they were given out sequentially at that point in time. And now it's just a system to where whenever you apply, you get a number. You just get a number, and if it's 15 years later that you actually pass the exam, similar to your example, you get that number.
And that's for tracking purposes because we're now keeping all of our information digitally. So reference it for.
Oh, that's fine. It's more of a curiosity question than anything.
Right.
It ain't going to change the price of tea in China. I understand that. My next question was concerning the budget. Looking at it just face up, we have from time to time discussed the possibility of a staggered renewal system, so that this off and on switch that you referred to in this budget wouldn't be there. It would be more steady. And I just was curious what your opinion or feeling about that would be.
I would say, first of all, take it from two different issues. From a accounting standpoint, it's not really critical for us whether we have an up year or down year, as long because we can forecast that. As you know, you have to be 2 years. If you're 2 years in the red, then we have to go up and have a sunset hearing, and they could possibly reconstitute the board or sunset. But for us, it is certainly not. There would be some advantages, but I'm not sure at this point that the advantages outweigh the disruption that it might cause.
Obviously, it would require a statute change because our statute simply says all licensees renew on the 31st of December of every odd numbered year.
Right.
That's what our statute says. As far as advantages, we're around 1,200, just to use a round number. If you cut that number in half, that's 6. Well, that's 600 individuals that Ms. Mulder has to deal with at the end of each year versus 1,200 at the end of, for example, this year. This is a renewal year here. Right. That's a situation. My greatest concern is just exactly what you said about being in the red. Obviously, we don't want to be that, but from a standpoint of predictability of when you might go to the red, or if you are in the red, and being able to analyze whether or not it's necessary to increase your fees that the registrants pay. That's one of my bigger concerns.
It's interesting, though. I mean, we could get into a real deep discussion about the 2 years because, and actually, in my ciphering since I've been here, I have determined that the boards that renew the way you all do actually stand less a chance of running into a sunset situation over being in the red, because you have a year that's always extremely high and a year that's extremely low. In the sunset provision, it has to be 2 years consecutive. And so it's actually kind of a false insulation against finding yourself in.
Well, and then the other concern there is, the governor has the ability to kind of come get his money, let's call it that way, and hasn't chose to do that. And
actually, it's the legislature that can do
well, okay. I used the governor. Bad example. Thank you for correcting me.
Yes,
I
sir.
appreciate
Yes,
that.
sir.
The legislature has the ability to come get their money if they saw fit.
Yes, and we know that happened. I think that I was not here at the time that happened. I suspect most of the people in the room were not here at the time that happened. But I would be shocked to see them do that again anytime soon, because there was a whole lot of blowback over that. And I do think one of the things that we've talked about is it's if you take your program again with the number of licensees that you have, 1,100 licensees, to have $150,000 sitting in the bank that we basically can't do or return back to your licensees, that's a conversation that we want to have, and talk about how are we best serving the licensees by that method. And I think probably if we took a show of hands in here, we probably I'm sorry. What did I do? I think, of course, the last thing we ever want to do is raise license fees. I mean, that is the last resort at any time. You are not having any trouble. Again, I mean, I'll give the credit where the credit is due to Director Mulder and Director Avers. They are managing your business. And, what we would like to see is that we can continue to do the job that we're doing and have a license decrease. That's where we would like to get to, or hold the cost. And one of the things about these fees, some boards have not had a fee change in years, but as you know, everything else goes up. So, and because some of the fees are written into statute, as you said, your renewal date is written into statute. It binds us somewhat to what we can do. It does, however, make us, I think, better stewards, because we do have these limitations that we can't change, and we've got to find a way with the number of licensees that you do have to make sure that you stay in the black. Some of the industries were hit hard. The Contractors Board was hit very hard. The Real Estate Commission was hit very hard the last 5 years. Significant reductions in revenue, but we've still been able to, good management to keep those in check. So one of the important reasons that we want to do this is to have that discussion and to make you all feel like you can call us about those kinds of things, and that you do call us if you have questions or you want to discuss your license fees. It's your money. It's your board's money, and you are.
Let me ask question here, even though an up year and a down year doesn't matter at all to you as far as your accounting, and you get by that easily apparently, but as far as the workload on our administrative assistants here, it would be nicer, I think, for them if we could even it out. I'm just saying from their standpoint that she's not swamped with 1,171 applicants coming in and fees coming in for this year, and then she relaxes next year and takes Christmas off and doesn't have to worry about that. But then the following year she's back up again and does this kind of thing. So would it be advantageous to allow us to do that, and so we could make her workload easier?
Absolutely. I mean, I think that's a decision for you all, and certainly, I was going to say, I got sidetracked and never got to my second point, but from an accounting standpoint, it's irrelevant really to us. But from an administrative standpoint, it's entirely, it just makes perfect sense that it's going to be easier. I will say, and everything I'm saying here is going to sound like I'm against doing this, but as we move more electronic, we believe that renewals are going to get easier and easier and easier. Our renewal process already is much smaller. The time duration is much smaller than it's been in years past because we are going electronic. That being said, I still think that any evening of the workload on the staff is always helpful.
And I'm not saying that she's overworked or anything, because she hasn't said that or
You ought to
anything.
hear her
It just
talk.
seems like that rather than to have to, hustle to get everything done when 1,100 people, renewing their license this year, and then next year she doesn't have to do anything. That doesn't mean she's not busy next year, but I'm just saying that it just would seem from that standpoint, from the management standpoint of getting all these things out, it would just be a smoother operation from the standpoint of our board.
And I would entirely defer that to you all and the program, because I think that is, you all are the most affected and experts about that.
Now then, you mentioned too about monies and about going in the red 2 years in a row, that if we have the up and down years, you see that might not be a problem, but if we level it off, then would that tend to be a problem if it were looked at that way?
Well, I mean, I think
A lot of that would depend on leveling it out and who renewed when and where you for the first couple of years you probably wouldn't see a problem, but as your licensee population changed, as new people came on, you're eventually going to start to be unbalanced. So the initial balancing, it just plays out over time. We've seen that with other groups that have done it. So
and I mean, and again, it's back to the is having a 2 year. I mean, if we were going to get you there to where we wanted to say, okay, we know our expenses are going to be roughly this every year and our revenues are going to be roughly this every year, the goal of the department is to get those as close together as we can get them without going under and without going substantially over it. For my thinking is that we would be better off to be $500 short than $50,000 over, to collect $50,000 more dollars than we needed.
We have something that's new that will be totally new in next year in 13-14. Is part of our process for our examinations is handled through NCWS. Beginning January 1, that examination will become computer-based. So we will not be handling that money coming in to Donna, for example,
right,
and then money going back out to NCWS. It'll
right.
be that will just, in other words, some income and some expense will totally change. Well, in another year, in 2015, it's anticipated that the PS exam will also do the same thing. Again, more income and more expenditure being disappeared. So we're anticipating our budget, the overall total nature of it, of what we're seeing, these numbers, is going to change a fair amount. It's not going to change significantly enough to upset the way it is right now, but it is going to change. So we're in a changing environment with that also.
For earlier point on the staggered renewals, it would be easier. It is more than just Donna on staff. We do have 4 people on staff for the Land Surveyor Board, but it would be easier if it were staggered. But we certainly can handle it now. The real disadvantage, as I see it, to the licensee is if you, especially as these testing changes go into place, you could get approved in one part of the year and then get a very short credentialing time for your first period because it says in the statute your license will expire on the odd year. So you could pay for everything, get going, and have like 4 months till you have to pay to renew.
Well, in order to manage that, you would have to, when you manage the current renewal language, you would also have to manage that language at the same time if that change was ever made. Right.
But that would be the advantage, as far as I see, is that you could, as an out-of-state licensee or a initial upgrade land surveyor, you get a 2-year license from the day you were approved, and it would be a 2-year cycle from there. And everyone can monitor their own. It's monitored by a computer, their cycles and when their renewal cards go out. And it's not like staff has to, oh, I just know that I have to mail out 1,100 renewal forms in October. The computer does that.
We meet with all other boards across the United States through NCWS, and those boards have, as you can imagine, all over the gamut of how they renew. Some's on their birthday, some's on the day they pass the test. Some is in the month that they pass the test. Right. Some is, annually, some's biannually, and so forth. I mean, it's all over the spectrum. And I think the spirit of our concern is just simply that we want to be able to manage it the best that we can manage it, both from the efficiency of the staff to the management of the money, as far as how that's handled.
And I think a discussion to have then would be: do you want to have rolling renewals just like we do in most of our other programs? From the administrative side for us, anytime we can conform a program to what the majority of the other programs are doing, it's beneficial. And if we were to spread that out, again with the technology, I think because a renewal notice will become a much more automatic thing once we get the new system. It'll literally be that the system will prompt to send out electronic renewal notice that now your license expires in 90 days or your license expires whenever. So all those things become much easier for us to do. So it is a statute change to change it at all, but we would encourage you, if you want to have that discussion, or if you are motivated to make a change there, to have a discussion about all the options and decide what you think is best for your licensees. Because I appreciate you thinking about it. I think it's good that to consider the staff, and anything that we can do to even it out is beneficial.
The old adage, don't fix it if it ain't broke, and that's not my intent and the board's intent. But if it would just even it out and right. improve it somewhat, and then I think that the board would be looking at that kind of a change. But I certainly don't want to fix something that isn't broken because it's operating very well. It just, I think there are some ways, and we have discussed it, that it would even out the things.
Sure. All right, that's 2.
All right, we got 2 more. Now, these are the 2 most important questions I'm going to ask you.
Uh-oh.
The next question deals with this board's relationship with NCWS. Okay, and let me describe it as best I can, and I'll certainly yield to Nicole or Donna if I misspeak. Okay, NCWS. Are you familiar with the acronym? Okay, I don't mean to be disrespectful, but I don't want to say something that you don't know where I'm going. We have to join NCWS as a member board, and we pay a fee. And to the best of my recollection, that fee is $6,500 annually. So it's a pretty substantial fee. Okay. heretofore, before the CBT, the computer-based testing, takes into effect, we've paid fees back per examination, basically for them preparing it and them scoring it. And of course, we as a board provide a proctor to administer. Okay. You mentioned earlier, and I made very good note of this, in the 12-13 budget, the travel expenditure was more than it had been last year, for example. Okay, this is where I'm going. NCAAS funds individuals from member boards to attend their meetings. Okay, and Tennessee is one of two, if I'm not incorrect, member boards, and there's 66 member boards to NCAAS, because some states have two boards like Tennessee, surveyor and then engineer architect.
I got you.
And other states have combination boards. Plus we also include Guam, the Virgin Islands, and Puerto Rico, and Washington, D.C. So there's 60, anyway, there's other boards that make 66 for the total membership of NCAAS for member boards, okay?
Okay.
NCAAS funds member board representatives for the annual meetings. Okay,
Pays their registration.
Basically pays the registration and travel.
Okay.
Okay, I'll give you a good example. In 2010, Mr. Dillahay, who was the middle member for the board, not chapter, middle member for the board, and myself attended the annual conference in Denver. The total expenditure for our travel, for registration, motel, airplane, and reimbursement for meals and so forth, was in excess, I think, if I'm correct, $3,400. I think was correct for the two of us to go to that about a 5-day meeting, okay, 4 or 5 days. At that time, had this board been allowed to do it, NCAAS would have funded one member, which could have been actually it would have been me at that time, and then Mr. Dillahay, because it was his first meeting, they would have funded him to go. So all of that money would have been paid for. So what we did in that particular year was we paid $6,500 to be a member. We did not take their funding and paid another $3,400 to go to their annual meeting that we pay to be a member of. And then there's also a zone meeting that we attend also. So basically, I'm just trying to paint the scenario is that basically NCAAS is structured to encourage member board participation in their meetings, and one of the ways they do that is they basically, in effect, use the member fee that they charge your board and pay for your members to come so that you're aware of everything that's going on and so forth and so on. And typically they always have them in a big city, somewhere that's not close, unfortunately, but they do that. But they take care of those fees.
Not in Hawaii, right?
No, or Alaska, because we can't go there, if I'm not mistaken. But anyway, but they take care of that. And what I would like to see is, if it's okay through the department, I would like to see our board be able to utilize that in order that we offset some of what we're already paying.
And anything, as long as it falls within the policies of state government travel, we're absolutely receptive to that.
We have been told this board had not participated in NCAAS for several years prior to me coming on the board in 2009.
Okay.
And the first year, I went and paid for it myself because I wanted to go and felt like this board needed to be a part of it. Right. And since 2009, at least one member or more of this board has attended all of the meetings, and our board has to paid for us to attend those meetings. Whoever is going,
and we're paying the $6,500.
And we're paying the $6,500.
I guess I'm just a little. Why would we have not asked to have at least one of those trips funded by NC?
We were told we were told, how was it said, Donna? We were told that it was a conflict of interest, yes.
If we could, we can look into this and
Yeah.
see exactly what the policy states. I do believe it is because we have a contractual agreement with them
That's right.
for the testing services. But let us go back, let us look at the travel regulations and the policy and consult legal. I hate to speak to something
No, that's fine.
not
No.
knowing.
I
and if
didn't expect
something-
an answer to that.
And also, if something has changed and we've not been made aware of that, we want to give you the most accurate information.
Well,
So-
it's Galen can tell you when we go and they talk about that we're not funded. I mean, we get the big eyes all around the room like, well, why? All the rest of us are funded. So we just have to basically just say, well, our state won't fund it. But I really would like some attention paid to that particular issue, just because of the size of the money that's involved.
I mean, if we're paying funds into that and that funds are used to send delegates to that conference, I agree with Tim.
Yeah.
We've already paid some money to send us, but then the state won't let us use what we paid to them to do that. And
I'll
that's
give you an
the
example.
problem.
I'll give you an example to kind of help you with on the legal side. I believe it's Kathy or Kimberly. Okay, I'll get it right. I'm not real great with names. I apologize. I was asked a couple of years ago to be on a committee for NCWS, and being on that committee requires some travel. And in order to do that travel, NCWS funds that travel. Okay, and I wrote a letter and asked Ms. Goodwin to check with the department and check it all out, and also got letters from NCWS to explain, what I would be doing in this committee, so forth and so on, and that was approved. And from my venue of being on the committee and attending the meetings, I personally don't see a lot of difference in the business that's conducted, either at the committee level or at the meeting level, from the standpoint of being able to take benefit of them paying for the travel.
Well, yeah, and we'll have to go back and have a deeper discussion and then come back to you. I think on its face, though, the policy is to prevent any question of when you've got money going both ways. We're paying you. We're contracting with agency A to provide a service for us, and then also they're paying us money to do something. I mean, obviously you can understand why.
Oh, yes, sir. There's
So-
no question as to why the decision is made. I'm just curious if maybe we haven't looked deep enough.
Right, and we will look again and see. And a lot of times with associations, it gets, when we have to do our conflict of interest statements and things like that, it gets kind of tricky. If you serve on an national association board or a committee, and it stands to reason that you would want to take any opportunity you got to serve on a national association board or committee, but then sometimes those can be in direct conflict with your role as a board member at the state level. So sometimes, we have to take a look at those and get legal to talk about it, and but we'll do that for you.
I appreciate it very much.
Sure.
And I have one more
I
question.
hate to not to get a rebate if we've got one coming to us.
Well, that's kind of where I'm at. It's kind of like going to Walmart.
Doesn't
If they're
make-
going to give you $10 back, we deal with it.
Doesn't make good business sense.
Right. The last question I have is in respect to a committee that this board is authorized by statute to create. We have a committee called the Advisory Board. The purpose of this committee is to review continuing education submitted by vendors or sponsors, whichever you choose to call them, to be approved so that our licensees are able to actually take these and then get credit for the professional development hours when they renew their license. Okay? That's the criteria. We do not have anything in our statute that allows us to do one of two things. We don't have anything that allows us to charge the vendor or sponsor a fee in order to review their information, nor do we have in our statute the ability to pay the advisory board committee members in order to do their job. Now, my question to you is this. Just as we have a contract with our exam writer and proctor, would it be feasible to also, and also we have a contract with our expert witnesses also, so we actually have two separate contract areas working currently. Would it be feasible to consider in lieu of having to deal with the statute, creating a contract through the department to solicit for members for the advisory committee and be able to pay them some monetary stipend based on, program review or whatever the criteria may be once that was described. And I go there from the standpoint that I was on the board when we crafted the language or the criteria, not so much the language, but the criteria for the expert witnesses, so that was given to someone in the department, legal or whoever, and then a document was crafted, and it was appropriately solicited by the state, so forth and so on, and then individuals were chosen to do those things. So I'm just wondering if that could be a possibility in this particular scenario.
There's already advisory committee language in the law. Is that? I'm not familiar with that. Is that? Counselor?
Rob probably has it. Yeah.
Rules.
Okay. I'm sorry. It's a rule.
I don't have, out of my 24 boards and commissions, none of my advisory boards. I think it's not because the legislature was being stingy. I think it's because the nature of what an advisory board, it was kind of a one-time thing. You come in. Most times advisory boards are either promulgating initial rules or continuing education rules. They're typically set up for 5 years. They come in and do their business, and then they don't come in like you all do and meet on a regular basis. So
what we face with our advisory committee or board is they may review several hundred applications for continuing education. Before that really got into flow real good, this board was responsible for those. So they're actually an arm of our board, clearly, as you spoke. But the workload that they're involved with, in my opinion, is pretty significant. Especially to ask someone to do it on a volunteer basis for the betterment of their profession.
Let us get an answer for you.
I mean, I realize that the governor does not want to create any more fees or costs, and I understand that, and I don't blame him for that.
And Tim mentioned about charging the vendors. In this case, the monies coming from the vendors would generally be the monies that would go to the advisory board to cover this, even though it would come through our board here. They don't know who the advisory board are, who's on, the members of the advisory board. But those fees, whatever we would charge the vendor for reviewing 5, 50, 120 courses or whatever it is that they're going to send to us, whatever those fees are, that's what would compensate the members of this advisory board rather than the state having to pick up that tab.
In the sister state, just for your edification, in the state of North Carolina, they operate quite a bit similar to us per se, except they have a joint board. But they charge the vendor sponsor $100 per course. In other words, any new course, that's what they have to pay. Just to give you as an example.
Okay. See, that does doing that does two things. It gives us kind of quality courses, right, and it eliminates the junk that they would like to send in here because they're not being charged a fee, so they just load
Right, yeah, there's
folks down with this
no
job.
reason to be, yeah. And we have other programs where it's that way, and they, it's your onslaught of
You don't know where we're coming from, so that's,
I think it would get a little tricky with the payment, and those are things we'd have to, I think not in this setting but we can discuss it.
yeah, I understand.
Okay.
We appreciate that.
Absolutely.
Start somewhere.
Well,
Yes,
I'm
sir.
done with my 4 questions, and I appreciate all the time and your responses to all of them, and any consideration that you will give any of them.
All of them will
I'm
give
going to let
consideration.
these other fellas have at you for a while.
I do have one brief question. Maybe you can just touch a couple of bullet points on it. You mentioned the new licensing system that's coming through. Can you give us just some ideas or bullet points on what exactly entails in that?
I mean, it's basically an entirely new operating system for our licensing, which will have, I don't know how familiar you are now with what we have. So, but it's very, very limited in what it can do. Oh,
The new system is actually an upgrade of our existing system, several generations. So it will function for the staff a lot like the current system. Graphical user interfaces, it's not going to be mainframe-ish looking as it is today. A lot of it, there will be a online piece that will actually be integrated, whereas currently it's not as connected as we would like it to be, and it will be completely integrated. Users will be able to create an account and manage all of their licenses with the division. I don't know if some of your licensees are engineers or vice versa, or we have an esthetician who is also a funeral director, just a random. They'll be able to manage those licenses together. So there's going to be a lot of both internal and external value adds. So the boards have actually been going through their process requirements, and we're wrapping those up this week. So we're excited.
it's a little bit too. Every time someone says, "Well, it's an upgrade of the system we have," I kind of cringe because I'm like, "Oh, they're giving them the wrong idea." But the benefit of that is the lingo's the same. Lots of the lingo that they've used for 20 years with the old RBS system is just migrating right over. So you've taken out a huge learning component of it, and where we believe that we'll be able to more quickly move right into operation with the new system and devote that time to higher use for the staff. So, but it looks entirely different. I mean, it looks like a current piece that when you go on and look at that, it looks like a current piece of software, not something that was written back when you had floppy disks and you print it out of the front of your monitor.
It's an integrated system. A lot of things you'll be able to do online. We'll see a significant reduction in paper, plus any information that we get will be electronically made.
For example, would a registrant be able to do their PDH submittal online along with their payment online?
Their continuing education. It depends on what is required by the board. If the board requires actually having the physical certificate, yes, they probably could submit a version of it, a picture of it, but not if they actually have to have the actual piece of paper. They'll still have to mail that in. So it depends on it. It really depends on what your board requires.
Okay.
And forgive me, I'm not familiar with the individual requirements.
No, that's fine. And I wouldn't expect you to be.
But we very much would like to look at, as we go forward, if there is some specific obstacle to being able to do that, we want to talk about that and figure out how can we get you what you need and still allow that transmission to take place electronically. So.
It's a short one. It's a short one. I have been asked by several registrants if and when the fee that's charged to register online may change or go away.
If I had a crystal ball, I'd be in Philadelphia. But I don't. I can't tell you when. I can tell you that it will. I just can't say when. I can tell you it's a topic of discussion, and it's a frustrating thing to tell somebody that we have an electronic payment convenience fee. What? Isn't that? I mean, that's kind of an oxymoron, isn't it?
It's about 200 times what a stamp is.
Right. And I can tell you that we're considering lots of different things and discussing how we get to that place. Because, I mean, we believe that the fee that we have now that we charge, even if we were to forfeit it, it would actually save money by processing those payments electronically. So we hope that there'll be a different solution, but that is the level of commitment that we have to eventually. And we think that the new system is going to be one of those things that kind of walks us into that occurrence. We can't take debit cards right now. So we want to fix that. We want to be able to do business with people the way they expect to do business. The governor very much feels that way.
A ballpark idea when the new licensing system will come into effect?
Come into effect, actually start where there's no going back and we don't go back to the old system. What would you?
I guess really, you know, when
12
can
to
we log
18.
in and start creating these accounts you mentioned and things like that?
The online piece is actually December 2014. Is that the? So you're looking at a year. I would say a year to 18 months. I'm not exactly sure on the online. Of course, at this phase of the project, all of those. I don't want to say a date and it not actually. So 12 to 18 months, and then phase 2, I believe, includes the online piece.
But I mean, the contracts are done. There's literally people here on site every day that they're stationed now here in the building. I mean, that's how far along we are in the implementation process. Working through with the programs on their needs assessment, but with things like this, dates generally come around to kick you in the pants. So, but sooner rather than later, we believe, much sooner than we thought. To do this, I have got another meeting that I'm actually half an hour late for, so upstairs.
We
But
apologize.
I can come
I
back. I'll be glad
apologize
to
for
come
having
back.
long questions.
No, it's not. Don't apologize at all. I
we
apologize
appreciate
for
your
not
time.
scheduling more time.
Appreciate your time and your willingness to answer our questions. And like I say, from me, and I hope the whole board too, we sincerely hope that a couple of them that we've asked you to look into, you will, and get back to
Absolutely.
us.
We'll look into all of them, and I certainly do not mind coming back down. They may be done up there, for all I know, by the time I get there. So if they are, I will gladly come back down. I enjoy getting to talk with you all, and we want, one of the reasons for doing this is we want to have an open line of communication and a relationship with you, and for you to feel like you can contact us anytime and ask questions or give us advice or observations or things that you think we can do better. We will all can only be lifted up with that. So you all be safe, especially going back to L.A.
Thank you very much.
Thank you very, very much.
Thank y'all.
Why don't we take about a...
I do want
Yes,
to do
sir.
one more thing. I want to do this right here. This gentleman right here, Dennis O'Brien. Kimberly Whaley's done it too, not to take away from her. She did the first 4 classes, but we asked a couple of people in the department to conduct the customer-focused government training. So, and as I always top of his regular duty, so I just wanted to recognize him. He really.
Thank you very much.
Thanks.
I think it brings us to a good stopping place, so let's take about a 10-minute break, and then we'll reconvene.
Yes, sir.
Like 10-minute break?
Okay, it's now 2:40. We've had a short break and had a very good meeting with the assistant commissioner, and very informative, and I certainly hope that they do follow up as indicated and get back to us on a few of those points, and they'll be positive. Let's return to our director's report, and Donna.
Okay, NCAAS and Tennessee Specific Sub-Surveying Exam is being given in Murfreesboro on the 25th and 26th of October 2013. We have 33 candidates scheduled to sit for the exams. I'd update on CBT. All I have is that I have put some information out on the website informing the future applicants or applicants what they need to do and what they need to go through. And update on the newsletter is we're still working on it. We had to make some revisions to it, and it's got to be reviewed now by Nicole and information officer and whoever has to review it, and then we'll get it on over to Graphic Arts once it's approved.
I would simply like to be of record on the newsletter as saying this has been the slowest one that we've had since we drafted the newsletter, and I feel bad because I think that the registrants anticipate when things come out and they look for them and then they don't get to see them. So I'll take that burden on my shoulders, but
we're working on it, so
be good to get it out as soon as possible.
And as far as the budget information, the commissioner told y'all that, but I'll just reiterate. FY 2010-11, we had total expenditures of $177,084, total revenue of $41,320, and our adjusted balance was $85,681. FY 2011-2012, we had $172,133 total expenditures, $373,073 total revenue, and our adjusted balance that year was $280,921. And for FY 2012-13, we had $178,373 total expenditures, $38,589 was our total revenue, and our adjusted balance this year was $141,137. So we're in the black.
Calendar year, does it end, June 30?
And our current budget information through August 31st, our land surveyors activity report as of October 21st, 2013, we have 825 in-state or active in-state land surveyors, 346 active out-of-state land surveyors, and 69 surveyors in training, 40 inactive surveyors, and 33 retired surveyors, for a total of 1,313.
Thank you very much, Donna. Appreciate that. Any questions for Ms. Mulder on any of her report or anything else? Okay. The next item on our agenda is the denial application appeal from James Powers.
Mr. Powers' application was denied in August because he said his NCAAS record was not current. And his letter of appeal is in the documentation is behind the synopsis of why he's appealing it.
Page 30.
And I have his hard file too if you need to see that.
Donna, if I recall that application from when it was reviewed, the NCAAS record that was contained in his application file that we reviewed, I recall that the date of the record was stamped on it, if I recall correctly, and it was several years old.
Let's see. Yeah, it says his summary as of 5/16/2008.
It could be. That could be.
Do you want to see this?
I'm sure it's the same file we looked at before. I'm
Yeah.
sure. And that's what I recall having been the reason for us
And I
understanding
think-
the date of the record
Right.
that was contained within the application.
And I think his thinking is he's renewed it every year, so
Right.
it's current.
Sure.
That's what let me see if there's anything else in here. Oh, here's. Updated registration.
According to the NCAA records program account status, he has requested, and the request submitted a request. The request has been transmitted. It's been submitted to Tennessee 3 times: in July of 08, in May of 11, and also in April of 13.
Right.
According to their records. Yet the one we have seems to be stamped in 08, which does not coincide with any, well, the only, yeah, okay, 08, yeah, July 08, is that when it's stamped on it?
May 08.
When?
May.
May,
Let me show
okay. Well, he requested it, his request was in July of 08. Basically, is Mr. Powers asking this board to now approve his application? Is that what this question is? Or is he just simply trying to verify that his record is current?
He said he was told his record was current when the application was sent on April 1st.
My comment to the members would be this. The record we received has a date on it of 08. The application based on that date. The record that we received also addresses an unusual amount of potential disciplinary actions. I'm not going to say that they were, because I can't recall if they were actually founded or not. And from my standpoint, I'm concerned as to that track record equally. So, asking us to approve his application based on the fact that he says that his record is current, then I personally have no pleasure in doing so.
Mr. Chairman, I agree with a lot of what you said there, but I do think in the opportunity of fairness to the applicant, as we would, I would hope that we would suggest to all applicants, that if in fact that was the basis for the denial of application, and in fact his record was current, I would suggest that we re-review the application based on the current information and make a decision from there.
I have no problem with that, Jay. No problem whatsoever. However, that review will not occur until February.
That's fine.
If that's all right.
If that's the quickest that we can do it, then
Does
that's
he
the
need to
quickest we can
send
do it.
a new, up-to-date NCAAS record with the current date on it?
Absolutely. Absolutely, I think you should. I mean, that's the basis of the application. The application requests a current NCAAS record. I think we need to have that physically in our hands as a part of the application.
Yeah, I agree with you.
The primary concern in my mind about the currentness of the record is some of the things that the record has disclosed to this board.
Oh, I agree.
Relative to the applicant.
I agree, but I think in fairness to the applicant, we should, if in fact he has all the check boxes
Right.
and everything is current, that we owe him the opportunity to re-review it.
Certainly. Well, what I was going to suggest at the end of my thing, what I was going to suggest was that based on what he submitted, it would not allow us to today approve his application, but it would allow us to re-review. And
Yes.
I think that's what you're saying.
That's exactly what I'm saying.
Okay.
Yes.
I agree with that 100%.
Yes.
I agree with it.
We're having a discussion about the 10-year thing. Under the law, in that category, TCA 62-18109C, it says that if they have practiced for 10 years or more, or at least 10 years, they don't have to, they're exempt from B1. What is that? Next page. It says,
Clarified, it has to be 10 years of practice.
Right.
Acceptable to
any
the board.
person who submits evidence satisfactory to the board that
Hey,
the person...
stop. What did you just say?
I know. Evidence satisfactory to the board that the person has practiced surveying for no less than 10 years shall be exempted from subdivision B1.
Not question, this board does not question that the gentleman was originally licensed in
Right.
1997 in the state of Oklahoma. But we question the satisfactoriness of the information provided to this board.
But what I'm talking about is that exempts him from the exam.
Allows him
Allows him
to
to
apply for
allows
a
him to
license.
apply for the examination underneath that part of the statute.
There's no other, and unless possible, there's no exam.
Looking page, please.
Let me get it out. No, it's old.
The C part.
And that's all he would have to take.
Does he have 4 years or 2
19,
years experience?
he's been
Then they can make
licensed.
years of
Right.
practice.
So does he have to take the 2-hour
If they
exam?
say he does, he does.
They have, they,
In lieu of getting,
I understand all that. The exam is what's throwing me off.
But under no circumstance do we.
No reference to it in the little c, nor is there any underuse applying
Let me give
of
you a
reciprocity.
hypothetical then. Let me give you a hypothetical on it. Where is it? Evidence satisfies.
Practice surveying less than
That's
no
it.
less than 10
You're
years. They
right
just
on
said
that
they had
point.
no question that he practiced 10 years.
Okay, suppose they practiced 10 years and it's not.
I thought that's all we were talking about.
All ready for us to do some board function here? Do we have further discussion about the Mr. Powers issue? If we do not, then the chair would entertain a motion
Can I,
as to
before
how
we
we
make a
need
motion,
to.
can I just
Yes, ma'am.
clarify
Yes,
that
ma'am.
I just sent him a letter back and tell him that we will re-review his application in February as long as he submits a current NCAAS record.
Must be dated current, not stamped
Right,
current.
must be dated current.
Dated current because of the scenarios that the NCAAS record depict about his history as a licensee in multiple states. By it being dated in '08, there could be something from '08 to now that should be in that record. So we want a record that says it's current as of, something in 13 or whatever. So we know that there's nothing else hanging around out there.
That man didn't send it. That's where it says 08.
Fair, Rob?
Person has 10 years. Pass the NCAAS exams. Not pass the Tennessee exam. That will be a requirement. Okay.
But that's what the application is for.
Right,
is it
that's
not?
what the application's
Just
for.
strictly
He
for
wants
the
to take
Tennessee
our
state
test.
specific, yeah.
He wants to take our test, but we want to make sure that he, like all applicants, fit our criteria. If I said that
We will
properly.
not license anybody that is below our minimum standards.
That's what he
Already
applied
taken.
for.
Yeah.
So he can apply, but he's not exempt.
Well, let me ask this question while we're in discussion. Do we then also want to allow his application fee to remain in place? Or, do we ask him to do another one? I mean, that's just discussion.
Yeah, I can't expect him to submit an additional application fee. I really can't on something.
wouldn't
But I
expect
think
him
that
to.
should be part of the motion, because that's part of what we're addressing.
Certainly, because he's not reapplying. He's just asking for a re-review of the original application.
Clear then, Donna? As mud?
I think
Okay.
so.
Okay.
Hope so.
Okay, so if there's no further discussion, Chair will entertain a motion.
So move.
Okay.
I'll second it. I'd like clarity on what the motion was, if we can reword the motion.
Yeah, go ahead there, Dale.
Well, I think what I understand the motion is that we're going to re-review the application with updated information from NCAAS, which would allow us to review the application, and his application being to take the Tennessee specific exam
Yes, without any extra additional fees
without any extra
associated with this re-review.
Okay.
I'm good with that.
Okay, so we have a motion
Yep.
with clarity and
Yep.
a second.
Yep.
And is there any further discussion? Okay, if not, I'll call for the question. All's in favor?
Aye.
Opposed? Okay. All right. We'll move on here and see what happens after this. Okay, let me go back to my agenda. Okay, next item on the agenda, report on the NCAAS conference in San Antonio, Texas. And I'll turn that over to Mr. Northcutt.
Hot. It was long and interesting. What can I say? For the record, the NCAAS conference in San Antonio was a most interesting conference. I'm not really sure what I need to add to what anybody else had seen out there, but as far as the continuing ed that was offered in various places I attended, those I thought that would be beneficial to this board and what have you, and I walked into one that just did not apply whatsoever. And after the session was over, the seminar was over, I went to the instructor and I said, well, I'm here as a surveyor and I got a whole dose of engineering and I didn't get any surveying, and this was dealing with something that we are probably going to be dealing with more and more here in the state, and that is oil and gas wells and fracturing and what have you. And this particular seminar was on fracturing, and I was as lost as a turkey in a windstorm. So when I went over and discussed it with him, I said, I know there are applications that need to be made because I am in the process of spotting one of these particular type wells. And I said, could you add this to your seminar the next time? And he said, I never even thought about it. But he said, yes, I can, and I should have. But beside that, as far as the rest of the conference was concerned, I'm not sure what I need to add to it, Tim. I'm not sure how I can embellish on what I thought was probably a pretty good conference. And obviously Rob and Nicole were there, and a lot of things came up dealing with computer-based testing, which is going to start in January. So deal on this thing. So what can I say?
Rob, you want to say anything particular about it?
I think our main interest, of course, is the progress on CBT. That's what our registrants want to know about. And possibly, I suppose some of you visited the testing centers that were going to explain how that looks as far as ease of use and accessibility.
Well, for Jay's benefit in particular, Jay, they're using 24-inch monitors for the exam. The monitor is set up as though it's, well, in my simple mind, two pieces of paper. So you could have what they call an embedded reference that is part of the test on one side of the screen, and you could have the question on the other side of the screen. So in other words, for example, let's say it was something relative to a horizontal curve, for example. Well, then you may have the horizontal curve formulas on the left-hand side of the page, and you may have the question directly in front of you. Sure. You're also allowed to take in an approved calculator, NCAAS approved calculator. So you may be there doing your calculations. That is one thing that they're looking into that they mentioned is possibly embedding a calculator also into the screen. Sure. So that you could hit something and pull it right up and just, calculate on the screen like a touch screen, kind of like you do at McDonald's or whatever, But the testing scenario and the screen, it's really nice. It really is. It's plenty large enough. The cubicle, there's plenty enough room in there. They have, for example, like this legal pad we have right here, they have a pad that is erasable. So when you do your scribbling and stuff on that pad, it's just like doing it on a whiteboard.
Sure.
Same sort of type thing. And you just wipe it off, scribble again.
Wow.
And of course it stays. Nothing comes in or out or whatever. Highly secure, highly secure.
Cameras?
Huh?
Cameras?
Yes, there's a camera. If I'm sitting right here taking my exam, and this is my computer here, there's a camera right up there looking directly at me, watching me the whole entire time that I'm sitting there.
Yep.
People, you not only have credentials, but people check you in, check you out. The FS exam has 110 questions. 10 of them are what are known as pretest questions, which means they're not actually being scored to your cut score, but they're being scored for their strength of questions so that the psychometricians can go through those and analyze them and see if this is a good question, a weak question, or just a way too easy question.
Does the applicant, are they aware of which questions?
No.
They're not?
No. They are randomly dispersed through the multiple categories that they actually take.
Wow.
There's a tutorial on it that basically explains how to use it, how to take the test, and so forth. And then when you get in the vicinity, there's one oddity in it. When you get in the vicinity of 55 questions, or the halfway point, and you decide you want to take a break and get a sandwich or go to the bathroom or whatever it is, well, when you get to that point and you hit the button, those are done. They're gone. You can't go back and revisit those.
Interesting.
Can't go back and revisit those. And then when you
Security
come back, you have up to 20 minutes. It's part of the window of time.
Right.
It's a 6-hour window. You have 20 minutes that you can actually take a break. Go get a sandwich, smoke one, whatever it is you do. And then when you come back, you fire it back up, and you have the rest of that time. Now, another interesting anomaly about it is let's say that you reach 55 questions at 5 hours.
Sure.
And you decide you want to take your break. You go take your break, but when you come back, you've got an hour to do them others. So, there is some time management involved in it.
Right.
So that's just a couple of the little bitty anomalies. And then at the end of it, they have a survey that they ask all of the examinees to actually take, because they're concerned about, was the screen easy to use? Were you able to maneuver from, one screen to the next for the embedded references and things of this nature? Because what they're looking for is they're looking for a base for going to the PS. Because the PS, as you now know, is a closed book exam now with a booklet of references. Well, that same booklet is going to ultimately become embedded references when that goes to CBT.
Yep.
So that's what they're trying to look at is are you as the examinee comfortable taking this test in this manner and so forth, which, the young folks coming out of college and that type of thing, it shouldn't be anything for them because they're used to the computers all the time.
I was just thinking when you mentioned embedding the calculator in, I was like, that just wouldn't work for me. I've got to have the physical calculator there with me.
Right.
So, but that's
Well, like I said, they're looking at that as
Some
as an option.
Yeah.
As an option.
Yep.
And but like I say, it's given at Pearson View Centers, and you're sitting in a cubicle, and the person beside you taking the accounting exam, the person on the other side could be taking a nursing exam, or the guy behind you could be taking a fireman's exam.
Sure.
So there's, the security of it is really good, and because basically what you do is you make application for a seat at a particular center, and they give you a time, and that's your scheduled time. You show up at 10 o'clock on Wednesday morning and sit down and take your test.
Sure.
And you pay your fee there and so forth. All that's all taken care of right there. And then Pearson View deals with NCAAS as far as the monies and so forth. They have a contractual. It's exciting, and it's really. Did you fool with it at all, Rob?
But I'm not trained that way. So.
What is the manner?
It was over on that, you know where we come off the elevator and they had the registration desk over here, over to the far side in front of the restrooms.
Yeah.
They had a little cubicle there.
Yeah, I saw
that and that kiosk area there, that's where it was set up.
Yeah.
And they had two of them sitting there. So you could just kind of go by at your leisure and, play with it a little bit and stuff.
Yeah.
What is the procedure or the manner in which the testing center garners the information that yes, this applicant has been approved for the exam? Is that through the NCAAS?
Yes.
Okay, so basically, the approved applicants are submitted from here to NCAAS,
Yes.
and then the testing center goes through NCAAS.
Now, there's different venues on that. We touched on it, I think, last meeting, was some states just allow an applicant to apply directly to NCAAS.
Yes.
But that's at the state, and we decided we wanted to review them beforehand. So they go through the same exact process they're going through right now.
Sure.
The folks that's taken the FS on Saturday of this week, the process they went through to get their sheet of paper with their number on it and there's the information, they have to take their driver's license in, and in the Pearson View they also have to do a thumbprint in the Pearson View. So I mean it's really tight security situation.
All right, now I have a question.
Yes, ma'am.
When their application is approved through us,
Uh-huh.
then I'll send them a letter telling them they've been approved. Then do they notify NCAAS that they've been
Yes.
approved?
It's their,
I don't.
no. They have
I
to
just send them the letter.
Yeah, you currently send NCAAS a list, don't you? In other words, the way we've been doing it.
I don't send NCAAS.
Do you not send them a list at all?
Once they register and
Uh-huh.
when they meet all our requirements as far as their exam fee and all that,
You just send them a
then
letter
I
and
say
say
them
that they're
approved
approved.
then.
Okay.
I just send them a letter, the applicant a
Yeah.
letter, telling him he's
Now,
approved.
the anomaly in this is where we've been approving only twice a year. Now, we can approve somebody and they have 12 months from the time we approve them to take that exam. So let's give an example. Let's say on Friday that we have some applications for the FS exam, okay? And let's say that they qualify. Donna notifies them next week or week after that, hey, you've qualified, and effective January the 1st, you will be able to take the CBT examination for the FS for survey, okay? All right. They will have from January the 1st to December the 31st of 2014 to take that examination. And anytime that there's a window, there's 2 month windows. There's 2 month on, a month off, 2 month on, month off. They'll be able to take it in any of those windows. Now, the thing that we had been discussing, and I don't know if we've ever made a final decision about it, is we have to make a decision how many times they can take that test. Because NCAAS says they can take it up to 3 times, and correct me if I'm wrong, Rob, but they can take it up to 3 times within a 12-month window. And it's automatic. NCAAS automatically stops it. So, it's up to this board to decide, is 3 okay? Is 2 enough? Is 5 too many? What number we need. We really need a decision on that.
Or now, don't we?
Well, that's in a 2-year window.
That's right.
That's in a 2-year window because this is a 1-year window scenario. See, we're dealing with a new animal now. Same test, different environment, but a new creature. So we really need to decide, what rules we want to put with it, so that NCAAS knows that if Tim Lingerfeld has taken the FS exam from Tennessee, he's approved to take it, that he has a 12-month window just like everybody else. But Tennessee says he can only take it twice, for example. Sure. Or he can take it 4 times, whatever. But that's some information that this board needs to transfer to NCAAS so that they know what the rules of the road with our folks are.
Do we know if NCAAS is open to things like that, to us subjecting how many times the applicant can take it as opposed to
Yes.
their standard rule? They are.
Yes.
And they should be.
Yes. Yeah. So that's something that's very important that we need to address, and it'd really be good if we address it at this meeting before we start in January.
And they'll let them take it 3 times?
If I understood it correctly, they have a 12-month window where they can take it up to 3 times. But you can only take it 1 time in a window. In other words, the first window is January and February. So you can only take it once. Okay? So you could skip the next window, which is April and May. You could actually skip that window if you wanted to and then take it later.
Why couldn't we do that? Just have 3 times.
That's
And then if
what I
they
say. We just need to discuss that.
If they don't pass it within the year, they're done. Till How long do they make them wait before they can reapply?
They,
Or do they have a
that's what they call a jurisdictional decision, which means it's up to us. You know, I mean, like I say, we need to decide, you know, how many times can you take it in a year? How many times will we let you take it overall before, you know, maybe, as Galen says, maybe we need to talk to you and look you in the eye and talk to you just a minute.
Absolutely.
You know. I mean, you know, that's something that we need to discuss about that particular situation, and we can discuss that a little later on the agenda, whatever. But that's very important because that's something we're going to have to manage because it's just a little different. The only thing I was going to say about the San Antonio Convention was there were a couple of items approved relative to rules of conduct wording, and I've went back through, and I know this is for tomorrow, but I've went back through the ones that we utilized in our rules of conduct where the changes were made and tried to highlight those changes in my notes just so when we get to them tomorrow that we can speak to those. But that was all I was going to say about it. Nicole, do you have anything about San Antonio?
No, sir, not today.
Okay. Okay. Husband that broke something, or somebody broke something down there, wasn't it? Oh, that was Gary Thompson's wife broke her, what was it, wrist or something, wasn't it? Yeah. Somebody broke something down
It was
there.
Gary's wife, I
Yeah.
think, that
Then she fell and broke her wrist or something.
from North Carolina. Gary Thompson, board in North Carolina, his wife.
Elected the new secretary,
New secretary.
treasurer there, yeah. Okay. If nothing else on San Antonio,
Okay. never
no,
mind.
go ahead.
All right.
No, go ahead. Go ahead.
Since you brought up this thing on the number of times we can take this thing,
I was going. We can either handle it today, or I was going to put it on Friday mornings, whichever,
doesn't matter with me.
whatever your pleasure. That doesn't matter. Got two more things in particular that we need to address today, and if we
Let's
want to
cover
come
those,
back
and
to
then we
that,
come back
if
to
that's
it.
okay. The next item on the agenda is discussion membership in Colonial States, and we have NCWS on that. Actually, Colonial States is a separate organization that is primarily made up of the states on the east coast of the United States, for the most part. Obviously, that's why they're called the Colonial States. A few of the things that they do, we've kind of been members of Colonial States off and on. We've not maintained a significant or a consistent membership. I think their membership is $250 a year, as I recall. Some of the things that they do, and we've briefly touched on this, and I hope we get back to it, is they write an examination. It's in I'm trying to think of the word. Anyway, what it amounts to is the examination is for photogrammetrists, and it has been approved by NCWS and by other states that are giving it. For example, Florida, North Carolina, Virginia, immediately off the top of my head, all give the Colonial States examination in order to assist in licensing photogrammetrists as surveyors. Now, they address how a photogrammetrist is licensed as a surveyor a little differently in each one of those states. And I would encourage each of the members to look that up and understand it in their own edification. But that's one thing that they do. And they maintain an item bank for their tests. They have folks that in the membership that help write the items for their examinations. At the meeting in August in San Antonio, they indicated that they are also in the process of beginning to write items for a GIS examination. As I've mentioned before, that's a pretty hot item for licensure relative to surveyors. And I look at it very positively from a standpoint it provides another venue for our licensees to have employment in. So this is something that they're working on. The colonial states, for example, let's say Virginia. In Virginia, when they do a photogrammetric exam, the colonial states provide it, and they provide it for a fee. Their membership fee would be higher than Tennessee's, for example, right now because we're not utilizing their exam, but they do it as a fee base because they also score it too. So that's some of the things that they do. They are also, in their meeting, they were also very concerned about engineering surveying, which has been a hot topic for NCAAS for the last year. And they're going to be looking to address that, so hopefully they can speak to the full NCAAS membership about that issue, along with a committee that's been assigned to it that's separate from the colonial states. Current chair of the colonial states is Doyle Allen from Virginia. Good membership, good attendance. It's something that I think is very worthwhile, and I hope that the board would have some willingness to consider it, maybe after further investigation or whatever. But as far as obtaining a membership in colonial states, I think we had one as recent as about 3 years ago. Donna, does that sound right? We just didn't keep it up. But I think that possibly in some of the directions we may be going in the future, that it might be a good thing to be part of it, to have some of their interaction that they have with other state boards and things of that nature in some specific. So that's my discussion on colonial states. So if the board wants to have a motion to join or whatever, we can do that, or we can leave it right where we're at and think about it further after further investigation. It's whatever the board's pleasure.
Donna, you said we used to be members. Is there any reason why we stopped? Just lapsed?
Just told not to renew it.
Yeah.
If y'all would like to investigate a little bit.
I think I would. They have a website or anything like that?
Yes,
Just general information?
Sure, yeah.
I think I'd like
or
to
you
browse it over.
you can call Doyle Allen in Virginia. Sure. Also, I don't know if you know Doyle or not.
I do not.
I'm sure he'd be glad to speak with you. Fine gentleman. Galen's met him. But I think that may be good. Well, let's investigate a little bit further, and we'll maybe address it at our next meeting.
Friday? Can we bring it up Friday, maybe?
Good, yeah.
Okay.
If you want to do a little digging, we can bring it back up Friday.
Be
then.
good.
Okay, I'll put that on here. Okay.
Friday agenda.
Yep. Right. Okay. The last thing I wanted to touch on, I spoke with Rob briefly the other day about this, and I think it would be a good idea for all of us. Sue and I have been through a public hearing, and Galen and Jay have not. And just for Sue and I's review and everything else, and also for Galen and Jay, I think it'd be good, Rob, if you would just basically give the members just sort of a roadmap of how you anticipate things will work tomorrow for the public hearings.
Well, we got 2 rulemaking hearings tomorrow. I've never done that before in 10 years I've been here, but one rulemaking hearing is usually quite a bit of work, but we got 2. We're going to do 2 entire chapters. So we've been through a lot of the heavy lifting. The board is, over a long time now, has put these 2 chapters the way that they feel they're ready to propose changes to the public. So tomorrow is going to be the public's opportunity to come in here and be presented with the board's proposals to amend the rules, which means that I have to statutorily read some information first, and then to read the proposed changes into the record, and after that we're going to give the public a chance to comment. We've got some written comments that I'm going to read into the record and give the board a chance to respond to that. But anybody who's here in the public will get a chance to comment. I will have to write them a written response, whatever you decide to respond. And you can take that under consideration. You can adopt the rules as you propose to change them, or you can modify them according to what the public has said if you feel like that's beneficial.
Robert, do we get copies of those written? We do. Okay, good.
It's on your iPad too, just in case.
This notice has been out there 60 days or more, I think, on our website as well as on the Secretary of State's website. So the public's already had a chance to review them and show up here and sign in. After you vote on how you want the rules to look, then I'm going to get you to consider a regulatory flexibility analysis, which is just a series of questions: impact on small business, impact on small governments, stuff that you have to do by statute. And then after we adjourn the meeting, I'm going to send the proposed rules to the Attorney General, who will review them for legality to make sure that we can do what we say we want to do. They send them back with comments almost always, but nothing substantive, just changing some words. After they're approved by the Attorney General, they go to the legislature, the Secretary of State, where they'll be for 90 days, after which time they'll become effective. Probably at some point during that 90 days, we're going to get a request from the Government Oversight Committee, the GOC, Government Operations Committee, and they will want somebody to come up and explain the rules to them so they can adopt them, because the legislature has to adopt them before they become effective. They can either do nothing and let them become effective, but they're probably going to ask us. So I will probably ask some or all of you to come up to the legislature at that time and offer responses to the legislators if that time comes. That's pretty much how it's going to happen. We're kind of in the stretch now, but these are the final two chapters. I think there's one more chapter that I talked to the chairman with that I think we're going to modify, and after that we should be pretty much up to date. Proud to say.
Robert, for the end of the public hearing tomorrow, I mean, it comes to a close and it's done and it's over. Does this board have to make a final decision on what the final print will be? This is it? Yes. Okay.
Vote on it, and that's the way it's going to be. Assuming the legislature approves it, and they always have. I've been up there before when they haven't for other departments, but they're not nearly as efficient as we are. So we always have all the answers. So no problems there. But you've had a chance to review both notices. All right. I don't know who we're going to expect tomorrow. I think there might be some people.
You have a preference which we tackle first?
I was just going to do them sort of in numerical order, but I don't have a preference.
Conduct first, wasn't it? Numerically?
Yeah, conduct's first. Continuing education is the last chapter.
Yeah, and I got them backwards on the iPad.
Doesn't matter, because I think we worked on conduct first.
Conduct first. We worked on it first.
Are there any rules that speculate how long, if a member of the public wants to come forward and speak about the issue at hand, are there any set rules about the time limit that they have? Or
I'll control that. Yeah. We're not,
if they wander off topic, they can't. And who controls that?
Also controls repetitive responses too, to some extent, right, Rob?
only the things that are open for amendment can be discussed. They can't just get up and hold forth about whatever they feel like talking about. It's not time for war stories and things like that. It's only to discuss these particular changes, because all this becomes a record. No filibustering, no.
I want to thank Nicole and Donna both for allowing us to have our public hearings on one day, so that we can focus, this board can strictly focus on just those public hearings and do as conscientious and as good a job as we possibly can.
Writing rules is a regulation. This is what you're here for. This is what you do. So, making the rules under the authority of the statutes. That's That's what you do. Sue loves it.
When we go back before the legislature, after everything. What are they looking for? Our rationale behind something like this, or what this?
Short answer is money. They want to know if it's going to cost anything. We haven't done anything to any fees or anything. That's the first thing that gets their attention. But they will ask questions about why are we fixing this now if they perceive there's been a problem. We usually don't get many questions. Nicole's been there and done it before, was soil scientist, which they had money problems, and that's just about all they talked about. They weren't concerned about really the science involved. But I don't really expect a whole lot of questions.
Just to clarify, the soil scientist program is fiscally in the black. It's just their
80 of them, and they said, well, why are we...
There's not even 80.
Okay, there's not even 80. Well, they
65 now.
Yeah.
But
So-
relevant. It's just they're fine. There's just very few of them.
ask questions. They'll ask something like, why are we regulating this? Which the answer is because you told us to. I mean, we had a statutory mandate, and that's what we're doing, and that's why we're here. But I think Mr. Dillahay was the one that presented last time we did anything. And I don't remember what they asked him.
Do what?
He volunteered, I let him.
Of course.
I don't remember what they asked him, if much of anything. I don't think it was onerous. If it doesn't, they may just pass without any question at all. They've done that before plenty of times. They put you on a consent agenda and you go up there and nothing happens and you go home. So they have their programs that they like to discuss, and I don't think we're
I'd like to pick up an item that's actually shown on tomorrow's agenda today, if we could, and that would be to receive comments from our TAPS representative. Did you have anything in particular that you'd like to tell us, warn us, whatever it may be, Leonard?
We did have our regular board meeting in September where we discussed several items. And of course, what's coming up tomorrow we did discuss. I believe Rob referred to a written letter from the president, and of course some of our concerns that we looked at. And I think that the one of your reviewers is going to be here. Mr. Craddy's going to be here and discuss some things. He'll bring some stuff up, and the president of the chapter will be here. We as a board are proposing some legislation. We're going to try that and see where it goes, and it has to do with meets and bounds descriptions, providing a service to Register of Deeds offices and things like that. So we're going to see where that goes. Big undertaking on our part through our lobbyist, and we're going to get a little education there, and that's where we're going. So, but we, of course, are concerned about some of these changes, and we've looked at them and discussed them, and we'll see what happens.
We always try to send our raw, really rough drafts through TAPS early on to see if we can get comments, and this is, I guess, came up later. I think you mentioned something about that. Because when it comes to time to have the hearing, we like to just have it almost as a formality.
Yeah.
But we try to get that stuff exposed to the practitioners, which are you people, early on.
Now, 3:35 Central Time. Anybody else have anything that they want to address today? Or I know we had a couple of items that we wanted to address Friday. We'll put on Friday mornings. Give us a chance, a little more research. Rob, Nicole, anything else for today? Okay. Seeing none and hearing none, like the preacher says, if all hearts and minds are clear, morning at 9 a.m. for our rulemaking hearings.
It isn't here, right?
Will that be
It
in
is
here?
right here. Right here.
Okay. Okay.
Did you